Hey, my trendies, trendsetters, and trendy tribe. We have reached the conclusion of McMahan Drilling and Blasting versus Marsau Scott. Because there are always so many lawsuits in Huntsville, I don't expect you to remember exactly what happened with this one. So we will review and then we'll get into the conclusion. So this will go in chronological order of when the documents were filed. I'll try not to take long. All right. So first up, on February 22nd, 2023, it was recorded by the probate judge that McMahan Drilling and Blasting filed a lien against one of the properties of Marsau Scott. It reads as follows. The said McMahan Drilling and Blasting claims a lien upon the following property, and it lists his properties in Huntsville, Alabama. This lien is claimed separately and severally as to both the buildings and improvements thereon, and as to the said land. That the said lien is claimed to secure an indebtedness of $61,874 with interest from, to wit, the 28th day of November 2022. That said indebtedness is for drilling and blasting of construction site, and it lists the Huntsville, Alabama address again, and says that the name of the owner or proprietor of said property is Marsau Scott, dated this 21st day of February 2023. And now I'm going to go over the actual complaint that was filed by the plaintiff, McMahan Drilling and Blasting versus Marsau Scott. They were demanding a jury trial, and this was filed September 29th, 2023, so about 7 months after they placed the lien on Marsau Scott's property. Okay, these are the facts according to McMahan Drilling and Blasting. It says in August of 2022, defendant contacted plaintiff to perform demolition or blasting work at his residence in Madison County, Alabama. Specifically, defendant asked plaintiff to perform blasting work for the foundation of defendant's home. So 6 months after they were contacted, just to keep the time in context, is when they had to file the lien against the property, because they were contacted for work in August of 2022. They filed the lien in February 2023. It says plaintiff agreed to perform the blasting work defendant requested. Plaintiff provided that it would give defendant an invoice for work it performed once it completed work on defendant's residence. At the time, defendant induced plaintiff to enter into this agreement, and thereafter, however, defendant knew he would not pay plaintiff for the blasting work it would perform at defendant's residence. In other words, defendant knew from the parties' first conversation that he could convince plaintiff to perform work on his residence by agreeing to pay for blasting work, that he would receive the benefit of plaintiff's blasting work, and thereafter he would not pay plaintiff for his work. Plaintiff sought and received a permit from Madison County, Alabama to perform blasting work on defendant's residence. And yes, I do believe this would be the bedrock property. It says plaintiff sought and received a permit from Madison County. Thereafter, on September 3rd, 2022, plaintiff performed the blasting work defendant requested. So August 2022, after completing the requested work, plaintiff presented defendant an invoice detailing and itemizing the work performed and materials used on the job. In total, plaintiff requested $61,874 for the work performed. Defendant refused to pay plaintiff for the blasting work performed on his residence. Plaintiff has attempted to recover those amounts defendant owes on several occasions to no avail. So count 1, breach of contract. Plaintiff and defendant contracted for plaintiff to perform blasting work at defendant's house. In accordance with that contract, plaintiff agreed to undertake the demolition or blasting work at defendant's residence. Specifically, plaintiff contracted with defendant to blast the foundation of his residence. Defendant agreed to compensate plaintiff for the work it performed according to an invoice to be submitted at the conclusion of plaintiff's work. The parties' contract is a binding, valid, and enforceable agreement. Plaintiff satisfied its obligations under the contract as described above. Defendant has continuously refused to meet its obligations under the parties' contract. Specifically, defendant has refused to compensate plaintiff for the work it performed on his residence despite multiple requests from plaintiff. These several refusals amount to a breach of the parties' contract. As a consequence of defendant's breach, plaintiff has not received compensation to which it is entitled, been forced to acquire legal counsel, and to institute this action. Wherefore, plaintiff demands judgment against defendant for compensatory and expectation damage in such a sum as a trier of fact may deem appropriate, plus costs of this action. Expectation damages are damages that can be recovered from a contract breach by the non-breaching party. It intends to put the non-breaching party in as good of a position as if the breaching party fully performed their contractual duties. Count 2, fraud. When defendant contacted plaintiff to perform blasting work at his residence and thereafter, he represented to plaintiff that he would pay plaintiff for the work it performed. Defendant's representation to plaintiff on this matter was crucial, as plaintiff would not have performed any blasting work for defendant without the guarantee of compensation. But defendant knew from the outset of the parties' relationship that he would not pay plaintiff for the work it performed. Indeed, in every instance, defendant represented to plaintiff that he would pay for the blasting work plaintiff would perform, including on September 3rd, 2022. He knew he would not pay plaintiff. Plaintiff justifiably relied on defendant's representation and performed the work the parties agreed to. Thereafter, defendant refused to pay plaintiff for the work it performed, leaving plaintiff uncompensated for $61,874 for the work performed. Wherefore, plaintiff demands judgment against defendant for compensatory, expectation, and punitive damages in such a sum as a trier of fact may deem appropriate, plus attorney's fees and costs of this action. Count 3, unjust enrichment. Plaintiff performed this blasting work at the express request of defendant. Before plaintiff performed the work, defendant agreed to compensate plaintiff for the blasting work. Under the circumstances of the parties' arrangement, plaintiff's reliance on defendant's representation that he would compensate plaintiff for the work it performed was justified. Although plaintiff performed the work, defendant has failed and refused to compensate plaintiff and thus has been unjustly enriched. Count 4, work and labor done. Defendant owes plaintiff $61,874 for work and labor done for the defendant by the plaintiff on or about November 28, 2022, at defendant's request. The plaintiff demands trial by struck jury. Trial by struck jury is a jury that is selected from a veneer of usually 40 people, from which potential jurors are struck by attorneys for each side alternately until a specified number, as 12 of jurors, are left. And I would just want to point out that the attorneys that represented McMahan Drilling and Blasting Company is Christopher Rogers. We nickname him Mr. Rogers over here, and Mr. Rogers is also the attorney that is representing Zen Gardens in Scholt versus Zen Gardens. So that was just a very interesting connection to me. Now that I've had time to think about it, the plaintiffs, McMahan Drilling and Blasting, they probably did have a really good contract, because if they wanted a trial by jury, that means that a group of reasonably minded people, if they, they're selecting each side and who they think is reasonably minded, would read that contract and clearly see that the contract was breached. So I thought that was very interesting. Now we're moving on to Marsau's attorney, which is the same attorney that's representing him for Scholt versus Zen Gardens as well. I think it's Mr. Anderson. Filed a verified motion to set aside entry of default. This is the same tactic, very similar tactic, that Marsau to me used in his deposition as far as the I didn't know. I won't say the I do not recall part, because I have to read it again to see, but he definitely always claims to not have known something. Very Carlos King-like. Oh, I didn't know. So we're going to read what Marsau's attorney filed on his behalf in response to the complaint. So this document was filed November 22nd, 2023, or electronically filed at that time. And the complaint from McMahan Drill was filed September 29th, 2023. I would say that would be about a month and a couple of days over, because I think you get 30 days to respond, and they went over the 30 days, and here is their reason. So the procedural history: plaintiff filed his complaint on or about September 29th, 2023. On or about October 5th, 2023, a return on service of writ was filed that purports to show Scott was allegedly served with the summons and complaint on October 2nd, 2023. On November 13th, 2023, the court, on motion from plaintiff, entered a default against Scott. Although Scott was aware of a dispute between the parties in July 2023 or earlier, Scott only recently discovered he was named as a defendant in this action. And I would like to recall that he's saying that he knew July 2023, but the lien was placed on his property in February of 2023. Further, although the signature on the return of service appears to be Scott's, Scott has no memory of signing for the package, never opened the contents of the package, and certainly had no knowledge or understanding he was being served with the summons and complaint. If he was in fact served with the summons and complaint, upon learning of this action on Friday, November 17th, 2023, Scott immediately retained counsel to defend this action. Then they basically bring up an argument and cite a case where they're saying they don't want a default judgment. They also want a trial by jury. Basically, I'll summarize that. It says there exists good cause to set aside the default judgment entered against Scott. First, Scott is prepared to present multiple meritorious defenses to the allegations of the complaint. To meet the meritorious defense factor, Scott need not satisfy the trial court that he would necessarily prevail at trial on the merits, only that he is prepared to present a plausible defense. Here, Scott contends the work done by plaintiff was done improperly and incompetently, and accordingly, plaintiff is not owed any payment or at minimum due to be paid a reduced amount. Additionally, the amount claimed by plaintiff in the complaint is not accurate in that it does not match the amount invoiced. Second, plaintiff will not be prejudiced by setting aside the default against Scott. Plaintiff will have ample opportunity to litigate its claims, and setting aside the default will permit a determination of plaintiff's claims on the merits. Third, the default was not caused by culpable or willful acts, as Scott only recently discovered he was named as a defendant in this action. I have to break away real quick because I would love to see time and date stamped emails between them of when the work was performed and him trying to say, Marsau Scott trying to say, this work actually wasn't up to par. I had another expert look at it and this was not performed to the reasonable amount of services expected. I don't think that's actually what happened, but I would just love to see the correspondence of him trying to claim this. Though the signature on the return of service appears to be Scott's, Scott has no memory of signing for the package. There you go. He does not recall. He has no memory of signing for the package, never opened the contents of the package, and certainly had no knowledge or understanding he was being served with the summons and complaint. If he was in fact served with the summons and complaint, Scott promptly secured counsel once he learned of this lawsuit, and he immediately moved to set aside the default. So Scott respectfully requests this court set aside the November 13th, 2023 entry of default. So the court had actually ruled to go ahead and make this a default judgment, just like a lot has happened when it comes to Stormy. There's a few default judgments against her as well. If you're interested, all you gotta do is check out, I believe, my Love and Marriage Huntsville playlist, and her court cases are in there as well. Okay, so then after the November 22nd, 2023 filing to try to set aside the default judgment on December 15th, 2023, and I know my historians will probably be able to tie in some type of fundraising or something changed. Maybe, you know, that video footage he kept showing of him in that building that's being built. Maybe there was a milestone payment made, a progress payment made. I don't know. But they reached a settlement December 15th, 2023. Notice of settlement. The parties hereby advise the court that they have resolved the disputes and claims. The parties are finalizing the necessary settlement documents and the joint stipulation of dismissal. So I waited until I actually saw the stipulation for dismissal because Scholt and Zen Gardens almost settled too. And then Zen Gardens was like, never mind, we would like to continue with the court. So I was like, let me just wait. So this was December 15th, 2023 when they said they were coming to a settlement. February 8th, 2024, it says, this is an order by the judge. It says joint stipulation of dismissal filed by the parties is hereby granted. Basically, both sides were in favor of dismissing this. And I wonder what was the settlement or what was the thing on why the plaintiff ended up saying, okay, we can dismiss it. Obviously, there had to be a good commitment of them thinking they're going to get their money because they already kind of won by getting the default judgment. So it's very interesting. That's all I have for this. Let me know your thoughts in the comments. Talk to you later. Bye. I've been taking my time. Taking